Thank you, Minister Shanmugam and Ms. Reid, for that insightful discussion. We will now move on to the first panel discussion, International Arbitration, Charting the Next Lap. In this session, the esteemed panel will take stock of international arbitration's evolution and its future against the backdrop of the profound changes that have recently impacted the globe, including the pandemic, technological advancements, climate change, and geopolitical developments. We are greatly honored to have with us as panelists judges of the Supreme Court of Singapore, the Honorable Justice Kinan Ramesh, and the Honorable Justice Philip Jeyaratnam. Justice Ramesh and Justice Jeyaratnam are joined by Ms. Lucy Reid, President of the SIAC Court of Arbitration, Professor Lawrence Bu, member of the SIAC Court of Arbitration, and Mr. Darius J. Kambata, SC, member of the SIAC Court of Arbitration. The discussion will be moderated by Mr. Toby Landau, QC, Vice President of the SIAC Court of Arbitration. Toby, please.
Ladies and gentlemen, honored guests, good morning. It is a great pleasure to be here and to see everybody in 3D. We have a challenging panel this morning. The panel itself needs no introduction. The issues are extremely demanding, and we have a lot to cover in a short space of time. I'm going to begin with a very brief introduction to set the scene. I will then sit back and relax and let everybody else on the panel deal with these challenging issues and give you the answers to all of the questions. It is a regular activity at international arbitration conferences that we mark and congratulate each other on our continued success in international arbitration. The cynical view, at least pre-pandemic, was that we did this in ever increasingly exotic locations, where the issues were the same and the self-congratulation got more intense. But of course, there are growing tensions in the system. And if one steps back and considers what may be current and future drivers of disputes, or key features of the global landscape that may become relevant for future dispute resolution, there are fundamental changes that we are seeing already, and even more fundamental changes that probably lie ahead. Now, not wanting to depress all of you at this early hour in the morning, the list of drivers in the future include quite a number of sobering matters, from climate change, food and water shortages, the development and difficulties with renewable energy, pandemic or post-pandemic stresses in the financial system, conflicts, as well as positive things such as technological innovations and further issues that may impact on our process. What is perhaps notable about the future drivers, about this kind of list, apart from them being largely deeply depressing, is that many of these issues were simply not on the radar when our current system of arbitration was formulated and when it was developed. And so what that may mean is that we have a procedural model at the moment that actually may be ill-suited or possibly out of date for the challenges and the dispute resolution landscape that lies ahead. That is a mismatch which has already been noted, in particular in investor-state arbitration. But the question for us is, does it run deeper and further than just investor-state arbitration? Does it impact on commercial arbitration? And does it impact on court processes as well, both in their own right and also in terms of their interrelationship with arbitration? So the question that we have is whether our prevailing model can continue as it is, or should we, when we look at the next lap, reconsider our processes, our model, and the way that we actually conceptualize the arbitration process for it to be able to cope with the stresses ahead. There may be great opportunities, but there may also be great difficulties. And the panel is going to address this by way of a number of different points, which we'll take step by step. You are actively invited to ask questions along the way. Whether your question gets acknowledged by me depends upon whether I can handle the tablet that I have been handed, which at the moment is already causing me some alarm, as well as a temptation to check my emails. I'm going to resist that and keep on this screen and see if I can handle it as we go along. But please do ask questions as and when they arise. So we'll start, first of all, with a little moment of possible self-congratulation before we move on to the harder period. And that is to look at where we have got to in the current lap to date before we move on to the next lap. There have been major changes to date. There are future changes which we will come to. But if we focus at the moment on what has happened perhaps in the last 30 years, 20 years, or even 15 years, are we right to say that the international arbitration process has coped well so far? And if so, how has it coped? What are the features that has allowed it to cope so far before we start to look to the future? So with that question, and this is my limited license to pinpoint people and put them on the spot, which will be short-lived. Can I ask, first of all, Lucy, without any prior warning, whether you would kick off on that issue?
Oh dear, thank you, Toby. I'll pay you back for this. The trying to avoid self-congratulation, my perspective, and it's a long one because I've been doing international arbitration for over 40 years, is that there have been great advances in the quality of counsel work, the quality of arbitration awards, institutions. I think flexibility has been shown to deal with new issues, complicated issues. I'm particularly pleased with the advances in diversity in the phases that we see before us. Some of that comes from, well, it comes from effort, but it comes from more training, more courses, which we never had when I started in arbitration in law schools, LLMs, the young arbitration groups, of course, just the development of things like FedEx and conferences. So the answer is yes, but I put a footnote here to say that some of that development has also led to more uniformity, in my view, on how cases are presented to arbitrators, the formula that are used as compared to the creativity that we had to use in the early days of international arbitration without all the models, without all the, jurisprudence constant. So that's something that we need to take stock of, in addition to the content points that we will be getting into. But on a report card, yes, I would give international arbitration, well, if it were National University of Singapore, B, but maybe B+ or A-.
Darius.
Thanks, Toby. That's a huge question, and I think let's think of the strengths of international arbitration first of all. Transparency, enforceability, adaptability. But I think in the years to come, with all the new problems that we all see on the horizon, the existing model has to be carried forward rather than junked altogether with appropriate modifications. And I think, just thinking out of the air, there are 4 or 5 areas where this is going to have to happen. The most obvious, and it stares us in the face all over the world now, is cost. We've got to somehow make arbitration a little cheaper. I'm not talking about the institutional fees. I'm talking about the cost of the whole exercise of taking teams of counsel across the world and making them sit in a location and arbitrate. The second is accessibility. And I don't mean only geographical accessibility. I mean accessibility to different systems, to different cultures, different financial models, things like that. The third really helps the first two, which is technology. We have technology now staring us in the face, and unless we use it, we'd be rather stupid. We've all adapted to virtual technology, and I think that's here to stay. It's not going to go away, and we should actually use it to assist in the first two, cost and accessibility. And the other two areas where I think there's going to be a change is specialization. Your tribunals are going to need more expertise. Now, by that, I don't necessarily imply that the arbitrators themselves have to be experts in the field. I mean, you could have that in certain areas of arbitration, like maritime arbitration, things like that, but you need not have that. I for one, have always been a firm believer that a good, just lawyer actually is the best arbitrator, regardless of the field in which he's arbitrating. But you would certainly need more experts. And that's going to carry us into, I know, other areas of this discussion on how to appoint the right expert, who should appoint the expert, and things like that. So that's going to be there. And the last area, which I think the arbitration world already saw coming, was more proactivity in the way tribunals operate. The strict common law model might now be a little outdated. I don't think we need to swing to the civil law model, but a sort of a hybrid, where there's more proactivity in the tribunal, not only in setting the agenda, laying down what are the undisputed issues, appointing experts, and the Prague rules, as we know, just 2 or 3 years ago, set that agenda.
So we'll come to the next lap, but just focusing on the current lap at the moment and the qualities in the arbitration process that we may think have made it a success or its weaknesses. Lawrence, can I just put to you, what would you say?
Sure, thank you. Thank you. I would want to also give a grade to that, just like what Lucy did. Lucy gave a NUS style of A+. Oh, sorry, B+, right? B, okay. I'll upgrade that to B+. I would say that over the last 20 to 30 years, a lot have been achieved. Particularly, I see a few areas. I think, firstly, the growth of institutional arbitration, I think, is an important factor. Institutions have grown. We see the ICC, SIAC, AAA, we see CTAC, we see many institutions have grown over the last 20 years. And they have played a very important role. They give structure, they give transparency, they give certainty to the conduct of arbitration. They come up with rules and procedure, guidelines, protocols, which many of us, especially those of us who come from common law jurisdictions, are used to ad hoc arbitrations. But over the last 20 to 25 years, there is a big leap in this area. The other thing that we can congratulate ourselves, first we congratulate the institutions, they're hosting these events. Must do that. The other one is, I think, UNCITRAL working groups has been doing a lot over the last 20 years to be involved. Michael Schneider is here. I think he was chairing the working groups. And to amend to promote the use of UNCITRAL model law. With more than 85 countries now, and more than 118 jurisdictions having adopted model law, we see a greater harmonization of the law of arbitration. Again, that is a milestone, and I think something we need to celebrate and congratulate. The third thing that I think we should be proud of and very happy with are the courts. The national courts in different countries have also taken a new leap by recognizing arbitration as part of their legal infrastructure and legal ecosystem. Not previously as they see as an appendage, irritating appendage. But judges in our courts, both here and in many other countries, have accepted arbitration, as well as mediation, of course, as part of the system that they are involved in. And they are supportive of it, quite different from the judges of old. So I think these are the three areas I think we should be celebrating and should be taking stock of, and how we build on from there. Thank you.
So just to pick up on the points that have been made as to where we've got to at the moment and points that we might congratulate ourselves on, I'd like to put both our judges on the spot, because the judges have a unique perspective. Apart from our colleagues already having been experienced arbitration practitioners when at the bar, you have a unique perspective in grading arbitration because you are seeing the challenges and the applications made to you, and in Singapore on a very frequent basis. if you were to put out of your minds any case that I might be arguing in front of you, what is your view at the moment as to where in the current lap arbitration has got to? Are we in a stage where we can self-congratulate ourselves, or do you see issues of concern from your perspective in the current practice? It's a very broad question, but just as an introduction. Perhaps I can start with Justice Ramesh.
Well, you got a case before me, so maybe I should ask Philip to answer that.
I think Toby appears before everybody, so if that were a disqualification, I think we'd have to keep silent for the rest of the panel. But I think that there definitely is some congratulation in order. But I suppose we can also see some of the stresses and strains that are opening up. And all of that in response to the burgeoning demand for international arbitration. And if we just, recap a little bit of the history, I mean, international arbitration grew very much as the handmaiden of international capital, and principally, of course, initially that was American capital. And we've seen the greater diversity and the growth of arbitration among other non-Anglo-American countries, particularly in Asia, arising as sources of capital have diversified. And so we now have so many disputes involving Chinese investors, Indonesian investors, and so on. And with that has come a much greater diversity of counsel. With the challenge, I think, that Lucy had adverted to of how do you make sure that quality standards remain high? And on the other hand, with that burgeoning demand, how do you make sure that arbitrators don't take on too many cases? And that's another source of stress and strain in the system. So I think when I look at cases now from the perspective of the bench, I would see, the main issue, the main reason why cases end up in court after awards is due to some disagreement about case management. It's about how the case was handled. And that brings to the fore the question of how arbitrators going forward are to have the resources, the skills, the equipment to deal with big complex cases, as the minister mentioned, and of course, as Chief Justice has spoken of.
So that, I think, gives us the lead in to, sorry, I don't know whether Justice Ramesh, no. So that gives us a lead in to our main focus. With that start, and with the concerns, well, perhaps first of all, congratulations on where we've got to, but the concerns about case management issues, that does really lead into looking at the next lap, which is with knowing what we know as to how arbitrations are case managed and how the system operates at the moment, what will be the future landscape where there will be tensions, where there may well be problems, and should we all as a collectivity be now charting the future and being preparing ourselves for what lies ahead? And if so, how do we do that? So with the question, what do you think does lie ahead? Lucy, do you have any thoughts as to where the issues will be or what we should be doing in terms of charting it?
Thanks, Toby. I'm going to leave case management
We'll come to the detail.
issues aside for now. But I think as we thought about this panel and the next lap and the list of new realities that Toby mentioned in the world, it's very important to distinguish between new issues that are going to be added to traditional or familiar commercial and treaty arbitration cases and litigation, of course, and entirely new subject matters and areas where disputes will arise that need to be resolved. Now, as for the first, I would say there are new expectations that we're going to have to be considering in almost all commercial cases, as well as treaty cases, sanctions, economic sanctions that come from use of force and threatened use of force, foreseeable climate change impacts on infrastructure, projects and development projects around the world. Sophisticated money laundering, corruption, and fraud that now can happen in our metaverse, and more force majeure defenses that will be connected to what's happening in climate change and also armed conflict. So I think that we'll need longer checklists as arbitrators and as counsel, and be prepared to add all those considerations to what we already consider. But I would beware of looking to wholesale change in how we do commercial or even treaty arbitration. And this is where I'm really not self-congratulatory, and we don't deserve to be self-congratulatory, is we in international arbitration are not legislators. We're not policymakers. We don't get to decide what issues that affect the world or sections of the world we would like to have put in front of us to arbitrator, but we're dispute resolution specialists who have to deal with the disputes that are given to us by clients, by parties in litigation, or as arbitrators. As to the second area I mentioned, I have no doubt, particularly for the younger practitioners in this audience, that starting now and through the next decades, there will be a genuinely new lap. There will of whole new disputes. We can go through the list: cryptocurrency, spying online, all sorts of issues, big climate change issues, government responsibility for that. And that's going to require serious preparation and new ideas in education for dispute resolution practitioners and deciders. And we'll get into some examples. I've mentioned in our early discussions, there'll be probably claims over Arctic resources, space debris, cryptocurrency, as I mentioned, which is already fast upon us. But those are two separate things to think about. And the second category may require a very different type of dispute resolution. I don't know if I would say it was civil law or inquisitorial, but more collaborative dispute resolution from the beginning, because the issues are bigger.
Lawrence? Sorry, Justice Rep.
Yes, I think Lucy makes a very powerful point. I think one of the most important things for the arbitration world to think about is whether your existing processes and rules are fit for purpose for new technology products and for new types of disputes. I mean, this is a conversation that the courts are also looking at. I mean, in terms of hearing these types of litigation, these types of products and these types of disputes. So I think the same question poses itself to this group. Are your existing rules, the way you resolve disputes in arbitration for what has been, in a sense, historical disputes or bread and butter disputes that have come before tribunals, are they suitable for dealing with new technology products? And I think that's going to be a vital question that you have to answer effectively to continue to be relevant and continue to grow.
Lawrence.
If I may just pick up from what Lucy just pointed out to us, and you in your introduction also talked about climate change. I recall that in my younger days, I heard of climate change in 1991, 1992, and about the UN framework for climate change. And I thought that's too far away. We are fine, we're okay. You know, but in recent months, I mean, just these few days, these few weeks, we've heard of floods in Pakistan and in New Zealand, and then you have drought in China. And strange time like this is supposed to be a very warm period in Singapore, where we have rain and cool weather. It is really dawning on me that things are really changing. So I think, agreeing with Lucy, I can anticipate that there will be challenges in this area, and there will be need for us to think through what are the possible matters that could be raised. And as recent as in June 2022, when the follow-up of the Paris Agreement, there's a Bonn meeting recently in 2022 in June. There are some groups, some states have already raised the possibility of claims that in terms of how climate has damaged their property or threatened food production, threatened livelihood. In fact, climate change is now a existential issue for the human race on this earth. So it's something that we got to be serious about, and it will raise questions. But for us in arbitration, then I think what's the relevance for us? I was thinking, assuming we got over the war, assuming there's no war and everything is all much back to normal in a new normal, then we consider whether or not claims resulting from damage inflicted by climate change is something that will be referred or could be referred to arbitration or to an international tribunal or to a domestic courts. What are the hurdles? What are the challenges that we think we'll face if we have claims in this nature? I would have thought that, like what you have mentioned, there will be challenges on energy, water, and food. So these are the areas that could give rise to real need for reparation or compensation. And of course, is arbitration a suitable modality for it? There will be problems. There will be problems of who are the claimants, who are the respondents. Do we consider climate change, damage inflicted by climate change, a man-made disaster, or is it a natural disaster? So issues of this nature will then point us to who then is responsible, who then can be the respondent, who then can be the claimant. So these are the issues when I think in terms of arbitration. But of course, there are greater issues for humanity, but I'm just thinking along these lines at the moment.
So the way that you're all depicting the next lap is in terms of types of dispute that look very different to traditional bread and butter commercial disputes, partly because of the significance of the issues, perhaps partly because of the breadth of the potential impact of the issue and the decision that may be made by a tribunal. That might challenge our existing compartmentalization between commercial arbitration, public international law, investor state, and each of those compartments has with it a separate specialized profession or a subsection of the bar. Darius, how do you see that in terms of how we see, we might say, what is commercial arbitration now?
Thanks, Toby. Yes, I entirely agree. We've got to now start thinking out of the box. Traditional notions of what is commercial have actually always varied between countries in any case. India at the moment is taking an extremely narrow view of the term commercial, which I think is wrong. Other countries like the US has taken a much wider view. So I think the wider view is going to prevail. But that still doesn't take us to solving the future problem, which is that you're increasingly going to have sovereign entities or indeed governments facing you in arbitrations more often than not as respondents. And I could even think of them as claimants. How are you going to bridge that divide? We are not ICSID. So these SIAC and institutions like us don't deal with these issues as ICSID issues or treaty issues. And I'm not sure whether institutions like SIAC can actually reach out and bridge that gap or should attempt to do so. We have to be more flexible. We have to take a wider view, yes. But whether commercial arbitration goes the whole hog and sort of throws in disputes that involve sovereign nations, that's an open question. I'm not sure that that's the way we have to go. The way we have to go is to build on our strengths. And in my first response, I know I got a little ahead of the curve, but there were those 5 areas where I thought there was improvement needed. And to self-congratulate, of course, we've heard that, the transparency, the efficiency, the enforceability. But those are the 5 areas which I highlighted, which I think will be the areas of the future. I'm not sure actually reaching out and altering the nature of commercial arbitration is a good idea.
Then, Lucy, do you have any comment? So let me then go for the kill on something which you're all already showing signs of resistance on. And that is, you're all suggesting that what we should be doing is tweaking the existing model. So let me suggest to you that the model itself needs reconceptualizing, rethinking, because the nature of the disputes that you have identified have a wider impact than the immediate disputing parties. So if a tribunal is going to decide an issue, for example, on climate change, and that has an impact on a broader range of interests that might not be there in front of the tribunal, isn't it time that we actually rethink the mandate of arbitrators? so that it isn't just a mandate to resolve narrowly the immediate dispute between the parties, but it takes on a broader significance that must take account of wider interests that may not be there. Please.
Toby, if only there were an institution that could perhaps invite submissions from independent counsel, invite parties or have the option for parties who are not directly involved in a dispute to join those proceedings. And if only such an institution also had an international flavor and character. Sounds like that might be something that should be invented. But on the other hand, it already exists. We have the Singapore International Commercial Court, which precisely enables or meets that particular concern, that you can have submissions from NGOs, you can have submissions from other parties who are not directly involved in a dispute. Of course, it comes back to questions of jurisdiction, questions of submission to jurisdiction, but for additional parties, you don't actually need that preliminary submission of jurisdiction. And I wonder whether what you're looking at, Toby, is apart from international commercial courts, the possibility of new international tribunals set up that perhaps have these features. But to an extent, they're already in existence.
So if we come to that in a moment about new tribunals, but for the time being, just focus on our existing arbitral model. We have, for some reason, universally adopted an Anglo-US adversarial model, whereby the tribunal sits and waits to be educated by the parties, rather than taking the initiative in a more inquisitorial fashion. So what I'm proposing to you is, don't we have to rethink that now? Because of the wider interests that may be affected, shouldn't that naturally lead towards more active case management, which is actually designed to take into account wider interests, might lead to more inquisitorial procedures, rather than simply the old-fashioned system? Lucy.
We are all resisting you, I realized. I think those changes that you just referenced should be made even in the most traditional vanilla cases anyway that we see, or at least the relatively bigger ones and more complex ones in commercial arbitration and treaty arbitration. And Toby, I know you and I agree on this. There should be more proactive tribunals. At the same time, as I mentioned, there's this, I'm seeing this uniformity in how parties of all nationalities do cases. And as again, maybe it's because there's so much more education, so much more training, so many more GARs, so many more conferences, and the council say, but this is how you're supposed to do it. You know, it's either the pleading model or it's the memorial model, and we'll deal with document production. And when tribunals suggest going off that model, that leads to the kind of cases that get to your court with saying, oh, well, the tribunal should have managed it this way and they didn't, and they disappointed us. So the mindset, to change that mindset, I think is going to have to go into the training and education. Having said that, where we've got new issues and more global issues, public policy type issues, then I think, yes, I agree with you. It is more imperative to have, I guess it's a situation, it's the same way I've always talked about treaty arbitration. Three people are picked to decide issues that have often, not always, often have public policy implications. And how are they supposed to do that? And we've seen resistance to having more amicus and more third parties. So it will take a change of mindset, and maybe, Toby, you're right, maybe it will come as people recognize, as Lawrence does on climate change, the impact that decisions do make on policy. And so we have to take on the responsibility ourselves to do that together.
But the rules at the moment allow for it. So
allow for it, but the parties don't want it. I can't tell you how many times I and others have suggested ways to do cases differently, that the council and the parties resist.
Look-
Kaplan, I mean, every single procedural order I issue, I say, let's have a midstream conference. Let's have an early opening. Let's have what we call the read retreat. Let's do this. And nobody wants to do it. So that I think is the real challenge as to how we make it happen.
Lawrence?
I agree that then that might be a mindset need for mindset change in terms of how we practice it. But I think the suggestion that Toby is postulating is the possibility of enabling or tribunal to be more inquisitorial, right? Is that your suggestion? And I think for us in Singapore, actually we have a provision for that. Section 12.3 of our IAA actually provides that tribunal has the power to adopt inquisitorial processes. But in real practice, none of us dare to suggest this to counsel. And if it's mentioned, counsel is like frown at you and nah, we'll go by this way. But I think you're right to say that with these new challenges that we have ahead, we got to think differently. We got to think of how to inquire more, how to include other parties who can contribute to the solution that we are trying to find for the disputing parties. And to go behind, there are 4 more fundamental questions in relation to the kind of disputes that we can anticipate in the coming future, and that is who are parties? A lot of them might be affected persons, but if they are not party, if we think of it must be purely consensual, where does consent extend? Does it can we have something like a long exit convention or the BITs where 2 states agree that any harm caused to an investor who is actually a third party beneficiary? They are not technically a party to the arbitration agreement, but they are parties affected by the measures of a state. So similarly, if we have a convention along that line and have an institution that can be set up to sort of administer this kind of claims, then it is possible, it'll be workable.
So
I think, but that of course means we have to have a new treaty, new convention, and to bring in claims of this nature.
Justice Sharma.
Yes, I was going to make the point, Toby. We all must accept that effective, efficient case management is key to an effective dispute resolution process, whether it's an arbitration or in court. So if the tribunal, having heard parties, feels that specific case management orders are appropriate, it seems to me a little difficult to process why it's such a challenge for parties to accept that. I mean, in the SICC, Philip has alluded to how we do things. There is very strict case management. You know that, and many of you appeared before the SICC will know this, right from the word go. And, there's control on document universe that's placed before the court, and strict timelines are imposed, and directions are made as to what issues should be dealt with in what sequence. So I'm struggling to see why it's such a challenge for the arbitration world to see that as a difficult pill to swallow.
So the 2 issues that arise here, one is the concept of strict case management itself, laying down the rules in the same way as the courts do. The other aspect is whether, in fact, the rules that are laid down in arbitration should now be reconsidered, so that what's being imposed strictly is actually representing a broader view to take into account the nature of these new disputes. So maybe the interests of parties who are not appearing in front of the tribunal, maybe the tribunal looking for evidence actively that's not been presented by the parties. Darius, do you have a sense of that?
I think what Lawrence said really.
No, you go.
Sorry.
Sorry, you go ahead.
What Lawrence said really exemplifies what all of us find in common law jurisdictions. There is a mindset where we are used to the adversarial system, and we just cannot fathom the inquisitorial civil law system. But as Lucy also rightly said, all the capabilities are already built in to the rules. And if you go back to the essence of what arbitration is, which is party autonomy, you choose your judge. And as long as the procedure the tribunal adopts is fair, they're not constrained by strict civil practice rules. And I think many tribunals and many of us practitioners are forgetting that. we're falling into this routine of following set practices that have evolved because we've taken part in arbitrations, we've seen things happening. So yes, I think the time has come, perhaps to give a nudge. I don't think it needs a dramatic transformation of the rules, but perhaps it needs a little tweaking. It needs perhaps practice directions, practice papers, things like that to suggest it's all right to break free of these shackles, as long as your procedure is fair and even-handed.
Can I ask Lucy? I'm going to come to our judge just by forewarning. By forewarning, I'm going to come to our judges in a minute, because one of the restricting issues here seems to be due process paranoia, which is, if I do something, what will a judge say later if there's a challenge? So that's a little indication to our judges. I'm going to ask you in a minute about that. But before I get there, I want to ask Lucy, do you see a difference in this debate between commercial arbitration and investor state in terms of what the tribunal should be doing, whether the tribunal should be taking on a responsibility actively to cast the net wider than what is being presented by the parties?
First, on due process paranoia, I've spoken about this a lot, and I agree that with Judge Ramesh, that there's no reason for tribunals to be so worried, because if you look at the case decisions on setting aside, that the courts almost unanimously support tribunals in doing things, being proactive in case management when there are complaints about due process. One thing that helps is when institutions change their rules and put, back spine strengthening rules out. In general, do I see a difference between commercial arbitration and treaty arbitration? Absolutely, because most investment treaty arbitrations do, when they get into fair and equitable treatment and expropriation, do touch upon very broad public policy issues. And there are different responsibilities for tribunals there. And all the more reason for the practitioners who are involved to be less cookie cutter and more thoughtful about what issues are being discussed, and for tribunals to be more proactive to get issues on the table with or without amicus groups. I think it's really apples and oranges in many ways.
Lawrence?
Yeah, I too agree that there should be, there's a difference between treaty claims and commercial claims. Where treaty claims, under the exit practice, you do have provision for non-disputing party interventions, and other people who might be affected by what possible decisions that can be made by the tribunal. So they should be entitled to give input. And in commercial arbitration, that will be not usual, if I might say, just a very mild term. But in fact, if you suggest this to counsel, they'll probably think that you have gone beyond the scope of the reference, and then threats will be there. And therefore, threats of setting aside, that you're not following the agreed procedure when actually the law provides for it, that possibly you can inquire. You have a broader mandate than what is specifically set out in the terms of reference or the statement of claim and the pleaded case of the parties. Sometimes we forget about this possibility. So I think we need to re-educate ourselves, refresh our own practices, and bring to counsel and let them be aware that there's always this possibility.
So that takes us to our judges. One of the restrictions people feel is that they cannot be overly creative in the arbitration process because it may not be recognized in court. There may be due process complaints. A court might have a preconceived notion as to how an arbitration should proceed, and any significant departure from that makes it vulnerable. What is the judicial perspective, Justice Jeyaretnam?
Well, first of all, I'd say that the capacity to innovate is one of arbitration's great strengths. And together with that capacity to innovate, the possibility of flexibility. So really what we're talking about here is not so much strict case management as empowering adjudicators, whether they are judges or arbitrators, to adopt the right case management approach for this particular dispute. So then turning to the approach that the courts have, it is certainly one which is permissive, as long as the arbitrator has taken the time and trouble to consult parties on the proposed way forward, and then perhaps given them an opportunity to react to what the arbitrator puts forward as the procedure for the arbitration, then in principle, that is not going to be successfully challenged. So I think due process paranoia is an evil which should not be laid at the door of the courts.
Before asking Justice Ramesh if you have any comment, I'll just read out one question which is relevant to this. I've pressing all the buttons here, and the question is supposed to come up, but it's not. The question is, should courts do more to develop the jurisprudence around challenges to awards in a way which will help relieve some of the due process paranoia?
I think the jurisprudence is fairly settled. And I think it's really creative arguments that are being presented to the courts that need to be dealt with. But I think case law is fairly clear. And as Philip said, I mean, as long as the tribunal properly consults parties on the options that are on the table, and then having heard parties, has decided this is the best way to take the arbitration forward. I think the courts are generally are good with that. I would be surprised if there's a fear that a challenge would be made because a specific case management order has been made, as long as due process has been properly afforded.
Except that the concept of due process at the moment has developed on a traditional adversarial model that looks a lot like court procedure. So if a tribunal were to do something radically different, that is, get rid of all pleadings, for example, and ask each party to do something different from a full pleading or a memorial or some other creative solution, are the courts ready? This is a loaded question. How would the courts redefine due process, or is the sense that due process itself is sufficiently flexible as it is?
Yes, right. Well, due process is primarily about giving parties the opportunity to be heard. And so the difficulty comes when an arbitrator short circuits that process by taking a view or that is not to be found in what parties have submitted on, or is not something that parties have been given that chance to be heard on. So in and of itself, it doesn't stop doing away with pleadings, as long as the arbitrator is given notice that that is the way forward, and the parties have had a chance to say their piece on it, and then you move forward from that. Of course, if there's been well, perhaps it's getting too technical, but of course, if the rules that parties have adopted themselves require pleadings or require some form of claim, then those will have to be observed if one party doesn't agree to dispense with them. But the courts, I think there's a false premise in the question which Gerald has asked. Of course, Gerald is an experienced cross-examiner, so he's adopting a mischievous but common technique of cross-examiners in putting this forward. I think there've been plenty of pronouncements of the courts, both in Singapore and elsewhere, that the arbitrator ultimately is in charge of procedure.
Toby, this would be a radical change you've made me just think of, which is some sort of interim role for the courts in due process challenges. Because what happens now is early in the procedure, the tribunal may say, well, okay, you've each named your experts, your economic experts, turn them over to me, turn them over to us. We would like to use your experts ourselves to avoid the room full of documents. But then the parties say, all right, no, we won't do it, or they'll say we will, but under protest, and then the case goes on for another year and there's the hearing and all this money gets spent before the courts get to say, that was actually fine. That was even a good sort of case management. There's no violation of due process. Maybe we need a sort of a hotline to you two to vet some decisions in arbitration in Singapore. That's not serious, but the idea is that the way the system is set up, everything waits until the very end of the process to get
Yeah.
examined.
Yeah, yeah. Any other thoughts on that?
I'll be cautious about doing that because if you allow the courts to intervene in the ongoing arbitration, we may go back 25 years, back to the old system where, every time there's a challenge, you go to court. In fact, in Singapore, we've already done that in relation to jurisdiction. My favorite peeve about the last amendment to the IA is section 10, allowing parties to go to court whenever a tribunal says there's no jurisdiction. So that's something that I think we should not go back to.
Let me then ask the anonymous question I put on the screen, which I'm thankful that somebody else has asked and not me, but it's a question on my mind. 2021 saw several challenges, some successful, arguing that tribunals went beyond the scope of the pleadings and therefore outside their jurisdiction. Does that restrain inquisitorial procedures? Would any member of the panel, possibly a sitting judge, want to comment on that?
Okay, I think, well, I mean, perhaps there's a slight misphrasing in the question, because I don't think the challengers concluded that because tribunals made a decision that was not within the scope of the pleadings and on which parties had not been heard, that in and of itself meant that they acted outside their jurisdiction. I think, in fact, that the Court of Appeal has made clear the distinction between the two grounds of challenge. I think the trailing question to this of whether that restrains inquisitorial procedures, it comes back to what we have already, in a way, discussed, and undoubtedly, it is not. An arbitrator cannot act like an investigating magistrate in a civil law country. I mean, they cannot just decide what evidence is relevant and go out and get it on their own. That simply doesn't work for an arbitrator. But short of that sort of full-blown inquisitorial approach, there is a lot of flexibility, I think, and I think the courts would protect that flexibility.
If I may add, when I pointed out this provision, section 12.3, I was suggesting, I'm thinking that whenever a tribunal wishes to do that, you must inform the parties what you intend to do. So there will be no confusion that he is adopting a certain process that's allowed under section 12.3. Otherwise, it can be a challenge. Tribunal should not be going by himself to investigate the facts, go to the site and interview witnesses. No, I'm not suggesting that. I'm saying that, it should be some flexibility, like what Judge Philip said.
Yeah.
Yeah.
I think a better phrase to use rather than talking about inquisitorial, which has a lot of other connotations to it. It might be better to talk about adjudicator-led or arbitrator-led, and that perhaps is the role into which arbitrators can grow.
So one final question I put on the screen on the inquisitorial concept or the model. The question is from Anonymous: if we are to adopt more inquisitorial procedures, how do we ensure that decision makers are not inadvertently, through inquisition, augmenting or making a party's case for them? Any thoughts, Doras?
Well, the short answer is you can't. That is a tendency that a tribunal might have, and perhaps we go back into time-tested ways of safeguarding against that, which is balance. If you have parties themselves reading expert evidence, and in addition, the tribunal appoints its own expert. If you have consultative procedures, as Lawrence said, where at every step the tribunal consults the parties, takes their views into account. that might safeguard against a tribunal going off on a frolic of its own. It's really all a matter of balance. I don't think you can completely safeguard against it, but I don't think it's a bad idea now to have a tribunal-led inquiry or more proactivity from tribunals, especially in specialized areas and fields.
Let me now put the focus on one particular part of the process, both in arbitration and in court, and that is the use of experts. So we're talking about future disputes that will draw decision makers into ever more technical areas, difficult areas both in terms of policy and also issues of law, issues of other where expertise may be needed. And the question is, to what extent will there be this new emphasis on expert evidence, and to what extent is our current system fit for purpose? So first, if we start with arbitration, Lawrence?
Well, I would first response will be because of this new possible kind of claims, new technology. We're talking about blockchain technology. We're talking about climate change issues and damage. And when I look around at the current experts that we use normally, that we normally see in arbitrations, they are not of that genre. So there will be a birth of a new class or classes of experts in different fields and spaces. So I think there will be at least initial reliance on some of them. It might be a very small pool, but this pool will grow. And that maybe for a start, maybe party jointly appointed, otherwise you'll be tribunal appointed rather than a party appointed.
So let's pick up on that point. Party appointed experts as opposed to court or tribunal appointed experts. The current system, if one were to describe it neutrally, is that each side finds an expert that agrees with their position, pays them sufficient amount of money in order to generate confidence for them to be confident in their views, and they come and they provide their views, and you get opposing views, and the court or the tribunal has got to unpick that big contrast of positions thereafter. Is this a sensible, efficient way of dealing with the next lap of disputes? Lucy?
I think that's a leading question.
Not at all. It's totally open.
Parties are very resistant in all kinds of arbitrations to give up their access to their own experts, and those experts do get more into the evidence and discussing with counsel and know the case better than arbitrators ever will. But I think not ever will, but will take longer. I think that I can say already with cases that I have to look at it as the SIAC president or as an arbitrator myself, questions of blockchain, cybersecurity, data protection even, and are requiring already that the tribunal get earlier access to the parties' experts at least. And we're starting to ask for tutorials as arbitrators with the experts appointed by the parties. And it's necessary even for document production. I'm finding more and more. So I think that's one avenue that's a compromise, Toby, that we can use. If you add on top of that a tribunal expert, in some cases it will help, but it also does get very expensive and you need all these terms of reference. But tribunals can be more active to get more out of expert evidence in these new areas. More important, earlier in the process to help form the record that leads to the issues that need to be decided.
Darius?
You know, Toby, recall that the two of us were on a team here a few years ago, and we lost the side of the debate on experts. We were against party-appointed experts, and we're still both trying to recover from that loss and trying to regain that initiative.
Rather not talk about it.
But it's really a matter of taking parties or their lawyers into confidence at a very early stage in the arbitration. There's also a problem which we tend to ignore in tribunal-appointed experts. And that's double hatting. I mean, we are familiar with double hatting, arbitral tribunals or counsel, but are we going to come to the stage where there are certain experts who are known to have taken a particular position on that issue. And if the tribunal appoints one of those, isn't that really preempting adjudication by the tribunal itself? So choice of the experts, and the pool is going to be smaller and smaller the more esoteric the problem becomes, is going to be a real problem. I'm not sure how we should deal with the double hatting of experts.
So I just want to inject one other point here. If we are all drawn into more policy complicated areas because of the nature of disputes, one of the things that's said about party appointed experts is that they tend to polarize the debate. So you get, instead of a measured presentation, you'll get an extreme on each side. And that can make the decision-making process in sensitive, particularly sensitive policy areas, perhaps all areas, that much harder, because you're then left as a decision maker to try and unpick two polarized positions and find some medium.
So can I come in on that very quickly in pleasure? I think Lucy's solution may be the right one, which is you have your party appointed experts, but have a lot of hot tubbing, have a lot of interaction with the tribunal, and maybe the tribunal appoints its own experts only for that purpose, to determine areas of agreement between the party appointed experts rather than disagreement.
Can I ask Justice Ramesh, Justice Jeyaretnam, what's the court view on this? How does the court see the use of experts? Is it a perfect comfort with party appointed experts? To what extent would you consider it's appropriate to have your own expert?
So, I mean, if you look at the new SICC rules out of 14 2021 rules, you'll see that you need leave of court before you can introduce expert testimony, and you must persuade the court that expert testimony is going to materially help in resolving the issues, and you then have to consider whether the testimony can be given on the basis of an agreed set of facts or can be addressed by way of submissions. So it's not an automatic pass to bring in expert testimonies just because parties feel it's necessary. So I'm not sure whether that issue is something that is open for consideration in international arbitration, because if the tribunal says you're not going to call expert testimony, that raises other possible downstream consequences. So I mean, the way we have looked at expert testimony is that we must be persuaded that it's going to help us. And this goes back to the point that Darius made, that I think you also made, where you've got party appointed experts. You've got really two opposite perspectives on an issue which really that can't be so wildly apart. And it makes it very, very difficult, especially if it's a very complicated issue involving a lot of science or technology or mathematics or policy for the tribunal to come to a landing. So which is why it's important to have these conversations very early in the piece to understand why this is necessary and how it can be managed. And going back to the point that Lucy mentioned, tutorials and just bringing the tribunal up to speed on these issues is absolutely critical to the whole dispute resolution process.
Are there times where you think that you would be better assisted by your own expert rather than a party appointed expert?
Speaking for myself, yes.
Justice Jeyaretnam, would you say the same? Or
Well, I think it might be helpful just to situate this discussion about experts in a broader context, which is the context of what are the resources available to the adjudicator. And I think that's a much bigger question because, traditionally we have seen the adjudicator in a way like the lawyer, this sort of romantic idea of the single person, sitting alone and somehow coming up with the right answer. And I think given the way in which disputes are now so multifaceted, multi-party, multi-issue, it becomes increasingly challenging. And so the possibility of an arbitrator or a court having their own expert is part of perhaps strengthening the resources available. But it's only one aspect of quite a number of things, which I don't know whether you would want to discuss those in the course of this panel.
I mean, such as?
Well, I mean, for example, legal assistance. What is the role of giving should an arbitrator have access to legal research assistance, which doesn't come from counsel? Should a tribunal have access to case management resources? should a tribunal have access to technology resources that don't come from parties and from counsel? You know, we have this traditional model of everything comes from counsel. So unless you get something from that direction, there's nothing really the adjudicator is supposed to do. You just sit there and wait.
Yeah.
And I think that is the bit which perhaps is easiest to change now. I mean, there are some big issues that we started with, but this is one that perhaps the institutions like SIAC can consider. Can this be built into the rules? A strengthening of the resources available to individual arbitrators.
So we'll come in a minute to the institutional role on this. Just before we do that, I want to then put the spotlight on arbitrators. If the concern is that more resources are needed or specialization is needed for more complicated disputes, do we have to rethink who the arbitrators are? That leads to a question which has been asked if I can put this up, to what extent can concerns around disputing parties' resistance against fashioning more custom-tailored procedures be addressed by doing away with party-appointed arbitrators? Now, it's an old debate about whether we should have party-appointed arbitrators or institutional appointments. But for our purposes, the question is, do we generally now need to think about more specialized arbitrators somehow, and how do we achieve that? Doraz?
Specialized arbitrators have always been around. It's nothing new. And as I said, my personal view is that arbitration is much more than just knowing about that topic, because as lawyers and as judges, of course, you have to deal with a variety of topics. As long as you get the specialized input, what parties are looking for in arbitration is that adjudication, that decision-making. And often a specialized arbitrator might not have that perspective. So I'm not in favor of actually having arbitrators who are qualified in that field. You can always bring in that expertise through an expert. And I think I'm not saying that you don't have arbitrators who are also qualified in a particular field, but I don't think that should be the objective.
Let me then ask Lucy, you have particular experience with standing tribunals, if we're talking about specialized fora. Do you have thoughts as to whether now is the time that we actually need to set up more permanent style tribunals? And if so, how does that work?
I will answer that, but in terms of that last question, I would say the resistance that I've seen from parties to novel ways to structure an arbitration have nothing to do with whether the arbitrators are party appointed or not. I mean, occasionally a party appointed arbitrator will defend its appointing party's resistance, but I think it's a different issue.
Except that, the problem with party appointed arbitrators is if you want to have a specialized tribunal, the dynamics of appointment mean you won't get it, because you will appoint a senior judge if the other side appoints a senior judge, so that there's a balance. If the other side appoints a retired Supreme Court judge, you're not going to appoint a technical expert on climate change because of an imbalance, even though the tribunal might need that.
I agree with that, but in terms of whether they want to be more inquisitorial, that's not the same. I am willing to predict that in the next decades we will see more standing specialized tribunals for issues such as economic impact of climate change, probably more in the cryptocurrency area, highly tech area, the way we have the World Intellectual Property Organization tribunals. And I've had the privilege of sitting on a number of such tribunals. One, the Eritrea, Ethiopia, Geneva Convention Tribunal, being a director of the Holocaust Tribunal. They're challenging, but it's actually quite satisfying to sit for several years with judges dealing with the same issues, the same law, and parties appearing before you. The thing that worries me is what I hear in the community about the desire of arbitrators in particular to set up such tribunals. And the one thing that we've really learned is the demand must come from the users. And in many cases, I think it will be from governments that they want these tribunals. It's not something if you build it, they will come, that you say, oh, now we're going to set up a climate change tribunal in wherever, Bermuda. That's not how it works. It takes demand from the users in order to do it. But I think it's a very good idea. Naming the arbitrators is difficult. Won't get into WTO or International Criminal Court, but we ought to be able to get over that.
Can I then raise one specific subject matter, which is, if I can put to Justice Ramesh, which is on the issue of cross-border insolvency. Going forward in the future, this will be perhaps a major, it is already a major issue. Perhaps it'll become even more significant. How do you see that in terms of the next lab?
Right. So I mean, the arbitration and insolvency or cross-border insolvency really the issue that needs to be navigated is arbitrability. Once you get around it, I mean, really, there's no problem, and it is a growing area, and it's being used in arbitration has been used. Arbitration as well as mediation has been used in. Let me cite some typical examples. So one area would be where you have got claims between estates across borders, and there's a argument as to how the assets are to be shared between the states, and Nortel is a good example of how this issue eventually was resolved outside an arbitration setting. But that's a good example of how you could employ arbitration to resolve inter-estate claims. The other thing that you could do is in a group restructuring. We've got, and you see companies are now organized on the basis of group. When the group becomes insolvent, each company is separate insolvency, and it might be located all over the world, or different parts of the world where the primary proceedings have been opened. And to resolve the claims between the respective entities within the group, arbitration is a very, very effective solution. And I use arbitration and mediation concurrently on this point. The third area that you could look at is post-petition claims. And you've got to put aside claims which arise from the insolvency, such as unfair preference, undue influence, and fraudulent trading, which are caught by arbitrability and that presents a problem. But aside from that, commercial claims which arise, which is brought by the insolvency representative against various parties, are open to arbitration. And it's important that you embrace this, because if you don't, the courts will get clogged up, because the courts are focused on really trying to revive the sick economic entity, and to plug all of this into that discussion makes it a very slow process if it's all stuck in court. So using ADR as a tool to deal with discrete issues in insolvency, in an insolvency is a very, very helpful process.
And so given that this is likely to be a future driver of disputes, do you have thoughts as to how we actually improve, sort of increase the activity in arbitration, or make it more, people less resistant to it?
Well, I think it requires a cultural shift. In the US, it's done quite regularly.
Yeah.
I think in Asia, people have not embraced it as widely. And from the point of view of Singapore courts, we have been certainly trying to encourage it a greater use of arbitration in these kind of settings. How it can happen, it's not very difficult. I mean, all you require is if you've got two estates, one in Singapore and one, say, in jurisdiction X, and there's an issue between the two estates as to how the matter should be resolved. All you need to do is open a communication protocol between the two courts, the Singapore court and the court in jurisdiction X, to discuss the suitability of having that particular issue resolved in arbitration. And it's been done before in the US and in Canada, in Mexico and the US as well. And I don't see why it can't be transplanted to Asia.
So Lucy, is this something that SIAC, from an institutional perspective, should be taking up?
The answer is yes, and the answer is it is.
Yeah. And what other, from an institutional perspective, I mean, we only got a few minutes left, but rounding off in terms of the next lab, where else do you see will be, what's the role of the institution now in dealing with these challenges?
Arbitration institutions have already shown that they can be leaders in change. For example, in appointing more diverse arbitrators, the institutions are way ahead of the parties and co-arbitrators. They're They've led with emergency arbitration, with asking for legislation in support. We'll be talking about ideas, and they're just ideas now. About one idea I have is, why shouldn't institutions require tribunals to report on carbon use and long haul travel and use of technology the same way that they report on how much they spend and how much they get paid. And institutions can consider rewarding greener tribunals, using greener hearing facilities with changes in, the fees that are paid. So I think that the leading institutions now, and there are more, as we heard from the minister, than there used to be, but it's still a relatively small group, and they're pretty well organized, and they can do more than arbitrators who sit in one case after another to try to lead change in the next lap. Toby.
We have 30 seconds left, so I'm going to ask one final question. If you project forward 30 years to the SIAC Symposium in 2052, and by the way, if you'd like to mark your diaries for this event, and we're sitting in the plenary session in 2052, will we be congratulating ourselves? Darius?
I think emphatically yes. If the past is anything to go by, the SIAC has been the most flexible, the most adaptable of the institutions, and that's what's required for the future.
Lawrence?
No doubt, except I won't be here 30 years from now. No. I'm sure things that we talk about today could well come to fruition. New solutions will be produced, new technology, new thinking. I'm sure we'll be ahead of the curve. Thank you.
Lucy?
I think yes, but we might all be wearing those crazy glasses and be meeting in the metaverse.
Justice Jeyaretnam?
Well, I wasn't so much thinking of the metaverse glasses as the fact that we'd probably need to be in our bathing suits and sunglasses.
And Justice Ramesh?
Absolutely. And I think Lucy's scorecard might be actually better than a B.
With that, we are over time. So thank you all very much. And I look forward to seeing you definitely in 2052, if not before. Thank you very much.